All right, we are live. Appreciate everybody tuning in. This is Stone Guy 223, and we've got some few people with us tonight. I've got a couple other links out, so hop in. But from my left, we'll do quick introductions. I've got Glock Guru,
Hey, thanks for the invite.
and we've got Mr. Eric. He's our resident attorney this evening. Be there, Eric.
Yeah, I'm here. Any question anybody wants legal, we'll try and answer it. At least for Florida, if it's out of state, we'll have to do our best.
And next to him, we've got Gun Websites
Howdy, thanks for the invite.
and the Tack Daddy. And then we've got Tack Daddy's probably taking his dogs out. And then we got Mr. Paul.
How's it going?
Who'd you say let the dogs out?
Well, Tack always takes his dogs out, like right when we're about to start this.
I just had to take my dog outside. The only problem is I get a bear problem around here, so I get a carry with me when I go outside.
There you go. And then we got Sean.
Howdy.
So tonight, Sean and Eric are the kind of the founders, if you will, of the Florida Carry. Is it floridacarry.org?
Yes.
So floridacarry.org. For any of you that may have caught the Tack Daddy show, we kind of started to get into the background and kind of how they were established. So I won't rehash that. But what I did want to do is kind of I've got some questions. B, I wanted to open up the panel and anybody in gun channels and on YouTube. If you have any questions, put them out there, and we'll try to keep this flowing with some audience participation and get some audience questions. Anything that you may be kind of iffy on the law, or just for your own peace of mind, if there's a legal question you want answered, kind of go from there. So real quick, we'll just kind of get your background, Eric, and start us off here.
Well, I started out in college working as an election volunteer coordinator for the NRA. That was kind of how I got involved in this. I met some guy on a internet forum who said he was thinking about starting some statewide organization. That I would an attorney help him out, and I figured for 6 months I could waste a little time doing it, because I figured that was about all it'd last. 4 years later, he's got this organization going strong, and it's become a major part of my practice. And so I've litigated stand your ground cases. I've taken them up on appeal. I've enforced preemption throughout the state. I've lobbied on bills that Mr. Crana has written, and it's been a heck of a ride for the past few years.
So you are a private practice, or are you part of a firm?
I work for a firm. It's a four-attorney firm here in Jacksonville. The firm's primary area is actually family law, and you'd be amazed how often family and guns intersect. The firm's primarily a family practice, but because of my background, I handle kind of the other stuff of the firm. The DUIs that the divorcing spouses get involved in, the domestic batteries they get involved in, and then I, of course, do the firearms issues for Florida Carry.
Okay, cool deal. And real quick, since you brought it up, kind of brought it up, the family and guns. Has Florida? Do you have a law or the word here? It's not a judgment but a clear definition for medical. Like, are they allowed to ask you if you have guns in your home on medical paperwork and stuff like that in Florida?
They passed a law regarding that in the 2013 legislative session. It was all the majority of that law was struck down by one of our courts, who said that it impaired the ability of the doctors to relate to their patients, and impaired the doctor's right of free speech, and so the courts pretty much struck that law down. Whether or not it'll be back, I'm not sure. That's one of those issues. It's very important to the people it affects. I don't know that it's that important to the larger group of the gun-owning populace. I think most of us, like myself, just tell the doctor none of your damn business. But for those that it's an issue for, it's a big issue. I mean, it can impact everything from whether or not your child has a good pediatrician to whether or not your elderly parent that needs extra care gets it. So, you know, I don't know what the future of that law is and whether or not it might be brought back in a different form, but unfortunately the initial version that was passed was struck down by the courts.
Okay, and another thing, kind of on that same, because when you said family law, I don't know if you meant like divorce and child custody, that kind of stuff.
Yeah, that's lawyer talk for we don't like to call ourselves divorce attorneys.
Okay, well that's cool because I wanted to make sure it was pertinent to the question I was about to ask. I assume that's what you were inferring, but has there ever been an issue, or have you ever seen an occasion where maybe the wife, and I'll be sexist here, I'm going to say wife, where the wife would bring up the issue that the soon-to-be ex-husband has firearms in the house, and that she doesn't, if she was anti-gun or she didn't want her kids around those guns. Have you ever seen that brought up as a sticking point for a situation?
It hasn't come into any of my cases personally yet. I imagine that sooner or later somebody will probably end up hiring my firm specifically because they know that's going to be an issue. I have represented, or I have consulted, for example, with cases where people who had an FFL license were being had their soon-to-be ex-spouse using some facet of their FFL license against them for custody, or was trying to make trouble for them with the ATF, saying that, you know, maybe they weren't properly licensed, or maybe they had lied on their ATF application, that type of thing. And so we've dealt with those issues definitely. I think it's just a matter of time before we have something like what you described. I will tell you, we did have a problem in Florida up until a couple of years ago, that the Department of Children and Families, in its adoption application and the private agency's adoption applications, they were asking questions like, do you have any firearms in the home? And if you answered yes, you had a firearm in the home, that could be a disqualifying factor to prevent you from adopting a child. Thankfully, before Florida Carry was fully formed enough to be involved, that was one of those things the NRA did take care of.
Okay, awesome. G-Webs, go ahead with that question while I look something up real quick.
Yeah, I was just about to say that this salsa is incredibly hot and I need to go get something more to drink, but I was just wondering if you're familiar with Massad Ayoob, and if you are, because he's another Floridian, what are your feelings on his positions on courtroom, or what are your feelings on his courtroom positions? Because I know that sometimes they can be controversial.
I am extremely familiar with some of his writings. I've been reading columns and blog posts and other things put out by him for years. I finally had the opportunity to meet him last September. Fascinating guy. He definitely knows his business. I greatly respect him. Actually, just called him a few weeks ago to consult with him on one of the cases I'm working on. So I definitely value his advice. I do plan on using him as an expert in some cases that I have going on that we just haven't gotten to that stage yet. But you know, he has more institutional knowledge of what prosecutors argue in some of these cases than probably anybody else in the country. Just based on the sheer number of cases he's testified in, and I think that makes him a really good expert. And I think that makes people in Florida that need him and need an expert, I think they're crazy if they don't look at him as a first option.
Awesome.
Right
I'm glad to hear it. I can like to say that I can consider him a friend of mine too, and I agree with you 100%. Good to hear you're in agreement.
Yeah.
So, Eric, what's well, I guess first, do you carry? Do you carry a firearm, a concealed carry?
Yeah, Alabama has a nice law that allows back in the 1990s at least, before their recent change, Alabama was a may issue state. Forgetting what their statute was, their practice was they were may issue for 19 and 20-year-olds and shall issue for 21 and up. And fortunately, the sheriff I had at the time was understood that some 19-year-olds were more than capable of safely carrying. So I've had a concealed carry permit for quite some time.
All right. And what is your what's your EDC? What do you carry primarily?
Springfield XDM.
All right. All right. And kind of along that same line, this is coming from Moonfood78. It says, how many, if any, cases of trigger jobs, etc., meaning modifications to the trigger, has caused an issue as far as the legal end of it that you're aware of?
That I'm personally aware of, none. I'm not personally aware of any. I would tell you, going back to Mas Ayoub, he has mentioned many times in different articles about problems that he's seen with them. Here's the reality, though. For those of you that don't know, I'm based in Duval County, which is the home county of Angela Corey, which I'm sure none of you have ever heard of as a possible of a particular white Hispanic gentleman down there in Orlando area. But look, if you had a gun that had a heavier than average trigger pull, Miss Corey would argue that heavier than average trigger pull proved that you really, really intended to fire that shot, and you had more than enough time to think about it before you fired it. And if you had a lighter than average trigger pull, it obviously that you were a dangerous, unconcerned citizen who was willing to carry around a superbly dangerous firearm that could go off at the drop of a hat. And if you have just standard average trigger pull, it's obvious that you are not a concerned citizen, or you would have made it heavier.
So it's damned if you do, damned if you don't.
Really, in all seriousness, the only thing I can think of in terms of an everyday carry firearm is if you do anything that's not factory, or get a gun that's not stock, not the standard industry average, you're asking for trouble. And that's an unfortunate reality.
All right.
Well,
that's
it's like you're leaving yourself open for the possibility that an opposing attorney can just attack you, right?
Well, look, if you get a prosecutor that has an anti-gun bent, I don't care what you've done, said, what you're carrying, what equipment you did or didn't have. You had a flashlight, you were looking for trouble. You didn't have a flashlight, you weren't being as conscientious a gun carrier as you should have been, because you should have had a flashlight to make sure you could see what you were shooting at.
Well, and along those, because this kind of ties into the initial catalyst for this chat, or this topic, was the warning shot thing. I mean, that's kind of a couple weeks ago. That's why we had Sean on and trying to get a clearer definition of the new law in Florida. But like you said, with the warning shots and how you referenced this particular, I'm assuming she's a DA.
We call them state attorneys here, but yes, DA, state attorney, same thing.
So she's saying that, if you have a heavy trigger pull, then you really intended to shoot that, and if you had time to think about that, then you had time to maybe choose another option. And that was kind of a sticking point on this warning shot situation, was the clear definition of a warning shot, meaning if you had time to produce a warning shot, wouldn't you have had time to maybe get away, or maybe think of an alternative to that warning shot? And what's the Like, what's the I guess the ramifications of a warning shot that wasn't I don't know how to phrase that. A warning shot that wasn't justified, I guess, for lack of a better term.
First of all, the whole idea of stand your ground, stand your ground immunity statutes, of no duty to retreat, is based on the premise that in the worst circumstance of your life, in the stress that is caused by that situation, the last thing we should be doing is second guessing the citizen or expecting them to make the most rational decision possible. There's an old Supreme Court case where the Chief Justice said that detached reflection is not demanded at the point of an upturned knife. And that really is the idea behind these stand your ground laws, behind these immunity laws, is we don't expect people to just go, to be able to rationally and cognitively consider all other options available to them. As far as bad prosecutors, they're going to argue what they're going to argue. There's not a whole heck of a lot we can do about them, other than try and pass laws that stop them and hope that we have good judges that won't let them make these salacious arguments to a jury to try and obtain a conviction.
Yeah, and here I'll add a little bit of a color to the issue here. There was a task force put out by the governor to review Florida's self-defense laws, including the stand your ground and self-defense immunity. And during that testimony, this commission went all over the state, and a prosecutor from Miami came and testified that he was walking down the street one day and came upon 3 men attacking a woman, attempting to rape her. He did not have a good shot. They were paying him no never mind when he started to yell, so he fired a warning shot. Because he had no other way of breaking that up, he did not have a good target that had a clear background with her behind them. The warning shot stopped the rape in progress. There are very few situations where a warning shot's a good idea. And if you do one, you better know what you're putting that bullet into. But there are those rare situations where it happens. And if this guy hadn't been a prosecutor, in many cases what the state attorneys have been saying is, if you point a gun at someone, what they were saying before this new law, if you point a gun at someone, you have to have all the justification necessary to take their life. And we know that there are many situations, someone being beaten in the face, someone being violently attacked by a criminal, and being punched over and over again in the face. And this happened in a grocery store. The guy pulled his gun and said, "Stop." He got prosecuted. He got faced with a 10-20 life conviction, 3-year minimum mandatory, and he's on probation right now because someone was beating him in the face, and he took out a gun and said, "Stop."
And the risk of that 3 years is too hard. The risk of facing a minimum mandatory 3 years, if you can do probation only, it's hard not to take that deal. I mean, we all say that, I would never plead guilty if I wasn't. But when you've got a wife and kids at home and you're facing that 3-year min-man, and all you got to do is admit or plead no contest in order to avoid jail time, it becomes a really tempting attitude, a really tempting proposition to take. One of the most interesting things to me was, while we were actually in the process of lobbying on the defensive display bill, there was actually a immunity hearing held for a guy named Mobley. Mr. Mobley was standing outside a restaurant smoking a cigarette with his friend. They'd had some guys that had kind of harassed him earlier in the night. They thought the guys had gone. They hadn't seen him for 20 minutes. They walked out to the car. Mr. Mobley rearmed himself because he had been in the bar. He had disarmed to go in the bar. He rearmed himself, put a sweatshirt on over his T-shirt to conceal the gun because, hey, no open carry in Florida. They're hanging out smoking a cigarette out front of the place when one of these two guys come back. One of them attacks his buddy, hits him so hard in the eye it breaks his eye socket. The other one comes around the corner reaching for something in his waistband. Mr. Mobley pulls out his gun, drops both of them, kills them dead. The second guy turned out to have a couple of steak knives on him. The first guy turned out not to have any weapons, but hey, he had already committed serious bodily harm. And the trial court's problem with Mr. Mobley was you went to your car and got your gun back on when you exited the restaurant where you weren't allowed to have it. And you should have either just left when you exited, because you had no right to stand around and smoke a cigarette after you exited the restaurant, even though you didn't know these guys were still there. You had no right to stand around and smoke a cigarette. And hey, why didn't you tell those guys you were armed and give them a warning shot first? And to me, I think that was one of those things that made the legislature really look at this and say, hey, we got trial courts out there telling people they have to notify, that they should have notified people. They should have fired a warning shot. You know, at that point, I don't think the legislature had any choice but to say, yeah, it's an option you have. But most importantly, I don't think the legislature has said it's something you have to do.
Right, and I think that's the more important thing that we should all take from this, is the fact that, you know, we could all debate whether or not warning shots are prudent or not, you know, whether they're a viable option. You know, obviously there's some instance where it would be a good choice, but decide all, you know, to set aside all that debate on whether you should or shouldn't, I think the fact of having a law on the books to protect someone in case that happens, that's the more important thing, is that Florida stepped up and got something on the books to protect that person, you know, if they had to fire a warning shot.
Here's what I think most warning shots are. And I don't have any statistical evidence to back this up. I don't have any great anecdotes to back it up. But I think, you know, we're all trained from an early age that taking a life is a very serious matter. It's a very important thing, and you don't do it lightly. And I think for most people, no matter how mentally prepared they think they are to take a life in defense of themselves or their family, when that moment hits, I think a lot of people, just as a matter of concern and as a matter of the ingrained societal norms that we've been taught, you know, maybe they hope against hope that they can scare this person away without taking a life. They can scare this person away, and a warning shot is what they hope will do that, thinking, you know, just to the side of them, and then I've got time to get back on target if I need to.
Sure.
And I think that societal pressure, that mental state, is what I think that's what
Right.
caused. I don't think most of the warning shots are warning shots in the traditional sense of firing straight up in the air. I think most of them are firing to the side because I just can't grasp the concept about
The
taking-
moral dilemma that.
Right.
Yeah, I think you're right. I think that's
Damn sure
pretty
shouldn't fire
accurate.
somebody for that.
Exactly. I mean, and kind of to transition a little bit is another question from the chat. You know, speaking of a self-defense situation or a lethal force situation, what's, you know, and I know this is obviously going to vary, but what's the typical monetary setback, the cost of defending? You know, let's say, you know, if it comes to a legal situation where you've got to go to court and you've got to plead your case and defend your actions, what kind of money are we looking at? I don't think people take into consideration the potential financial burden that you incur.
On a non-death case, I don't care whether we're talking a warning shot, a missed shot, an injury shot. Once that gun is fired, you can expect somewhere between $10,000 and $25,000 in general. Just count on it. Depending on how many appellate levels you go through, it'll go up. If you start talking about death cases, I'd say 25 to 50 is a bare bones minimum. George Zimmerman spent six figures on experts, investigators, and and again, this is estimates, but 6 figures on investigators, experts, testing, and other assorted costs before he even got to the stage of paying a single dime of attorney's fees.
Right. And there's been some criticism that he didn't go out and hire Masada or a use of force expert. If you wind up needing to use someone like that, you're talking thousands and tens of thousands of dollars more on top of just the attorney's fees.
Unless you're a member of the Armed Citizens Legal Defense Fund.
Well, yeah, I'm going to plug Florida Carry for a minute. I actually wrote a briefing. It's available on Florida Carry's website under their education tab that deals with what to look for in a self-defense insurance company, and I use the term insurance loosely. I'm not aware of any of them that are true insurance plans. Some are backed by insurance plans, some are not. Now, here's the interesting thing, though. Armed Citizens Defense League, of which I am a referral attorney, fails almost every test that I put forth on that post because they're not backed by a real insurance company. You have to pass a board review in order to be entitled to payment. It's not a. It's some plans give you have to pay as you go to your attorney, and then you get reimbursed if you're found not guilty. Other plans have true insurance where just the fact that you're charged entitles you to payment for your defense cost. Armed Citizens Defense League does neither of those. It has a board of people who review your use of force and decide whether or not you're really entitled to anything more than the initial payment they promise you. But based on their educational materials and who sits on their board, they are the exception to all of the questions that I recommend you ask of a group you're thinking about getting involved with. They're the exception that says, consider this group despite all the other rules. So,
but like you said, sorry to interrupt, they're not an actual insurance or anything. They're the legal defense fund, but those qualifications or the boards that you're talking about are to make sure that they're not going to defend someone who's not justifiable, correct?
Exactly. And I highly respect what Marty Hayes has put together. He has put together a great program, a great plan. But the point I was trying to make is I have a lot of suggestions of questions you ask. To most of those questions, ACLDN has the wrong answer to a lot of the questions. But
Can you give us?
But despite how many wrong answers they have to some of the questions, I still highly recommend them. In fact, I say that most people, if you're really concerned about the situation, if it's really something that you really fear, I suggest that it's not out of the question, considering the cost level of these programs, to consider joining 2 groups. And if you do that, it's ACLDN and pick one other.
That's what I was going to say. It's like a supplement for the $120 or whatever it is a year. It's like an extra.
The expertise and the experience that they bring to the table is absolutely, bar none, the best in the industry.
Okay, so that's what I was.
But as far as the actual insurance is, I understand that you posted this list of considerations. The short answer though is there stuff that's out there worth it, or is it just all?
Yes.
Okay.
Yes, look, it's to say it as bluntly as possible. If you are a person of no means, don't waste your money. For the most part, you're going to get a public defender. That's all you're going to be able to afford, and don't worry about it. If you're a person of a lot of means, you're going to afford your own defense. No big deal. It's those of us who are firmly within the middle classes, who have a lot to lose, who need these plans the most. And one of the factors that I list to consider, and this is one of the things ACLDN does not cover, is the cost of a civil judgment. If you were sued civilly, Florida has a very good stand your ground law, and as long as you have a good attorney, the odds of you getting hit with a judgment are slim to none. But if you don't have that, if you don't have a good attorney when you're facing that civil suit, you could be facing a judgment, and some of these plans will pay for a civil judgment against you, especially in the states where you don't have a great stand your ground law that protects you.
Well, let me ask you this, because we have another gentleman that we speak. Well, I use that term loosely, but he's in Wisconsin, I think, and he said that they have a state law that basically, if they're tried criminally and found innocent or not guilty, then they cannot be. It's like a blanket.
They're protected from civil.
Yeah, they're protected 100% from. It's not even an option of a potential civil suit. If
immunity for both civil and criminal.
Up until about 8 months ago, there were a lot of people who claimed to be self-defense gun lawyers in Florida who thought that Florida self-defense, Florida's stand your ground law would work the same way. That once you're tried criminally and given immunity under the criminal statute, you're cleared and you ain't got to worry about the civil suit coming after it. I was speaking with the attorney who represents one of the families of one of our famous or infamous stand your ground cases here in Florida. This gentleman was not successful in his defense, but the attorney for the family made the point to me that he didn't think that getting a criminal finding of immunity prevented him from going after you civilly. And when he gave me his argument, I said, that actually makes a lot of sense, and I think you got a good point. And sure enough, not his case, but another case came along a few months ago, and the courts are saying the same thing. Look, the civil plaintiff, the guy you shot that's going to sue you later, or his family's going to sue you later, he's not part of that criminal case. And so what they call res judicata, or the let the law of the case stand, it doesn't apply. It only applies to parties who were represented in the criminal case. And your victim, your civil plaintiff, your bad guy you shot, he wasn't represented in the criminal case. The state's not representing him, it's representing the state. And so since it wasn't representing him, he still gets to have his day in court and have his shot at you too.
Well, that's a good. I'm glad because this is another question from the chat. I know I'm kind of all over the place, but I want to get these questions in. But someone was asking about defending yourself in your home. Have you ever heard of an instance where someone was, used lethal force inside their home and there was still some type of charges or court proceedings that had to take place?
Actually, it was a good friend of mine from law school. Just before starting law school, she had a gentleman attempting to break in her window. She was actually on the phone with 911, and she was a U.S. Navy trained marksman, and she's pretty handy. And she was actually on the phone with 911, and the tape bears out her warning the guy that she's a good marksman and knows what she's doing, and she put one in his kneecap and put him in a wheelchair, and he decided to sue her anyway. And he was coming through her window. Now this is pre-Florida having a stand your ground law, so she couldn't even go after him for attorney's fees after the fact. Fortunately, the judge did dismiss that case very quickly once when the judge heard the 911 tape. That was the end of it. But it didn't mean she didn't have to hire an attorney and defend herself.
Okay, all right. Well, there you go. So the guy that was asking that just because someone was in your home doesn't necessarily mean you're going to be free and clear 100%. So that's.
I'll give you a more recent example of post stand your ground law problem. It wasn't a house. It was a client I'm currently representing. Showed up at his place of business. He's a contractor, and he has a workshop that he stores his equipment at and everything. He pulled up to his workshop to find 5 young men who had broken into his shop. he actually had a malfunction with the gun. Not he didn't actually shoot one of them, but he had a malfunction that injured one of these juveniles while he was holding them at gunpoint, and he is currently being sued despite Florida's stand your ground immunity law. And we're working on, we filed a motion to dismiss, but he's going to spend $5,000 or $10,000 to get his immunity granted. And he, in a civil case, the court's going to award attorney's fees against the plaintiff that's suing him. But what do you think that's going to be worth with a family that doesn't have two nickels to rub together?
Right, absolutely. So ultimately, to kind of hop back, I heard you correctly when you while you had some issues with the with that I'll just call it insurance for lack of a better term, that G-Web's referenced. What was that again? G-Web's, I'm sorry. That company or that insurance
Armed Services Legal Defense Network.
Okay.
Armed Citizens Legal Defense Network, ACL.
Okay. So that, even though you have some issues with them, ultimately either them or another
Well, I
company
think his
like
issues are calling them insurance and considering that your insurance, and with just that you're good to go. Because no, it's not. It's supplemental to insurance.
So would you recommend having some type of supplement insurance, either through that organization or others like it?
Well, like I say, if you've got some assets at risk, Florida, we have certain protections for certain things like our homesteaded property in Florida. That's why OJ came here and bought a house. There are certain things in Florida you just can't touch. But other things, if you have other assets, other property, and you really need protection, I'd say it's ACLDN and pick one of the others based on what your needs really are. Honestly, I apologize, I can't remember the names of which ones I recommended. Which ones I recommended were serious contenders. I think I listed about 5 or 6 of them when I did the briefing.
Well, that's encouraging because I can think of a couple, but I didn't. I mean, if you've had 5 or 6 that were decent, that means there's a lot of more than that even.
Well, I'd say there's 5 or 6 that are deep, that are good quality plans. None of them's ideal. None of them covers you for everything for every incident. Okay, look, and it's part of it's a failure of the market still fairly new. Look, your car insurance, it doesn't really matter what happens. Your car insurance is going to cover you for anything that happens with your car. And unfortunately, there's no real good plan that covers you for anything that happens with your gun. Different plans cover different things. Different plans have different focuses. Different plans allow you to pick your own lawyer versus using the lawyer that they tell you have to use. Some of them are backed by insurance companies. Some of them are backed just by your faith in that organization. And those are all things you have to look at, and you have to decide what's important to you based on your circumstances as to which thing you're going to focus on. And the plans that I've got listed on the Florida Carrier website are all quality plans in my opinion. They just have different focuses, and you've got to decide which ones are important to you.
Okay. Now, and G-Web, just kind of to hop around again, I'm going to let you frame this question because I wasn't quite sure how to ask it. But what's the question you posted in there about dealing with law enforcement in a self-defense situation?
Well, that's from the chat, but
oh, okay.
Which one?
I'm sorry, I thought that
we
was
have to
your
use our
question.
handgun in self-defense. How would we interact with? Well, I think that's the question. You go to different CCW classes. You're going to hear. You go to 5 different CCW classes. You're going to hear 6 different ways that you should always interact with police after a lethal force incident. Do you have a? I'm guessing they want to know if you got what your insight is on that.
First of all, I'm going to say this flat out. If the class was taught by anybody that wasn't a lawyer, take what you were told with a grain of salt. And more important, if it wasn't taught by somebody that's ever practiced criminal defense or self-defense law, take what you were told with a grain of salt. If it was taught, and this is not meant to be an anti-law enforcement comment, but if it was taught by anybody in law enforcement, then you need to completely disregard it. The bottom line is, and what people have to understand, police officers have a have a Supreme Court authorized sanction to lie to you in the course of their investigation. And the Supreme Court has repeatedly authorized that a police officer can lie to you. He can tell you anything he wants to tell you. He can talk about how, hey, don't you want to go home tonight? You know, if you just tell me what really happened, you'll be home and you won't have to worry about this. So police officers can lie to you at the scene, and they face no sanction, and you can't even tell a jury that they lied to you to induce your statement. So yeah, that's the reality. That's the facts. As far as my advice when I teach a class or when I have this question come up, it's, I was attacked. That's the guy that attacked me. I was in fear for my life. I'll be happy to talk to you after I've had a chance to speak with my lawyer. Number one, the courts have been clear. The officer cannot ever tell a jury that you invoked your right to remain silent. Not allowed to do it in any state. Number two, once every police department that I know of in this country has anywhere between 48 and 72 hours before that officer has to answer a question after a self-defense shooting. If those people who tell you that they're the experts, they're the ones that really know guns, they're the ones that really know use of force, if they get to shut up for 48 to 72 hours, why would you do any less? You are not in a position, I don't care who you are, I don't care how many times how good you think you are not in a position to be answering questions after you've been through that event. The only reason I tell anybody to give as much information as I just said is because in a state that has a stand your ground statute, I think that's the minimum information you have to give in order to have a shot at avoiding arrest that night and taking a chance at going home. If it wasn't for stand your ground laws that we have in Florida, I probably wouldn't even say that. That's just the advice I give to say this might get you home with the right officer, the right department, the right set of facts. I was attacked. That's the guy that attacked me. I was in fear for my life. Those are the basic things you have to say to be able to start your self-defense claim right then, possibly be able to go home that night, and be able to start the case later that you were clear from the beginning that that was your fear and that was why you were scared and that was why you acted.
Great advice. Yeah, that's awesome. So that's awesome. All right, let's see if we got any other questions. And guys, hop in, ask something while I'm looking for other questions.
Yeah, while you're looking at that, I always find it interesting that I like to attend as many CCW classes as I can. Sorry for the noise in the background there. I like to go to these different classes from different instructors and hear the different questions from students. Very rarely do they focus on the concept that you can get basically lawsuits against you after a lethal force incident or even just a CCW, whatever we call an encounter, both civilly and criminally, and sometimes locally and federally, right? So there's, if you pulled out a gun, fired a warning shot on school grounds, I mean, I can't imagine how many times you could go to court for that. And, we were talking a little bit about insurance. It's not all just about your court fees or your, the costs of going to court to defend yourself criminally, not to go to jail, but civilly, where you get sued for ruining some guy's livelihood, I mean, he was just simply breaking into homes and taking TVs, and you ended his livelihood, that kind of thing. You could get sued from that family, right?
Yeah, sure. And it's funny you mentioned the whole school thing. Yeah, I was doing some research the past couple of days on the Gun-Free School Zones Act for a class I'm doing for the American Bar Association in a couple of weeks, and I was fascinated to learn that talking of questionable prosecution tactics, we actually had a U.S. attorney a few years back argue that despite all of the provisions in the Gun-Free School Zone Act to protect people with a concealed carry permit from that state, we actually had a prosecutor argue that a particular state's concealed carry permit did not protect them from operation of the Gun-Free School Zones Act, despite what the law clearly said, because, hey, that state's concealed carry permit is too easy to get. It's too lenient in that state. And anytime a concealed carry permit's that easy to get, the federal court should just ignore that and convict the guy anyway.
Well,
I've always
that's pretty
wondered,
messed up.
the same way that the CCW permit, well, do you think that, I've never asked an actual attorney this, but does the way that a CCW permit, helps with the school, the Gun-Free Schools Zone Act or whatever, by giving you that authority to be in the school zone, how come that doesn't work at a post office, or does it work at a post office? If you read the post office sign, it says you can't be in here unless you're authorized. Does that CCW authorize you?
Doesn't help you a bit at the post office. There was an interesting case out of Colorado. I forget if it was earlier this year or sometime last year. Part of the postal regulations were struck down, at least for that district court. It doesn't do any of the rest of us any good. But in that district, as far as having one in your car in the parking lot, the postal regulations were struck down in that case. The judge's reasoning was sound. I think it could be exported to other districts, but again, you don't want to be the one that's a test case if you can avoid it. But no, it doesn't protect. The only reason that exception's in there for the school zones is because most everybody has to drive through a school zone on a regular basis. I mean, you think about your daily commute, your daily running around town. Unless you live in the middle of nowhere, it's pretty darn hard to ride around town and not drive through a school zone. I think that was one of those few concessions the NRA was able to carve out. But frankly, it wasn't near enough. They should have done more, and I don't know if they could have done more. They should have, but I don't know that they realistically could have. The school shootings happening in the 90s, early 90s were just too horrific and too much on the news to avoid something getting passed, and we're still paying for it today.
Yeah, if you ever think you want to be a test case, make sure you coordinate with someone like us so that we can avoid you having to wear a pair of steel-linked bracelets and eating bologna sandwiches for dinner as a guest of your local county.
So I got a quick question. I live in Ohio, and Pennsylvania, as far as I know, is a shall issue state. And my wife works in Pennsylvania, and whenever I called to get my permit for PA, because there's no reciprocity, like 5 counties just flat out said no. We don't issue out-of-state permits. So
does Pennsylvania issue out-of-state permits?
Yes, they do. I have one.
Okay. But those counties don't.
Right.
Okay.
Is that an option that they can have?
That's gonna, again, you're now outside of my jurisdiction that I really know about. But the place if I was going to research this and look at it, the place I would start would be to look at Pennsylvania's preemption laws, because it's very possible that they have a preemption. Many states now have preemption laws. It's very possible Pennsylvania has them. If Pennsylvania has a preemption law that leaves it to the state to regulate firearms, and they've told the counties to shall issue permits, that county refusing to issue them is not their choice anymore. However, the problem with most preemption statutes in most states, and it was a problem with Florida until Sean started Florida Carry, was there's no enforcement mechanism for the preemption in most states. So your options are hire a lawyer, spend your own money, get a injunction entered enforcing preemption, and oh, by the way, you can't get your attorney's fees refunded to you or paid in any way from the state.
Figures.
We don't have that problem in Florida anymore, though.
So it's probably easier, like I did, to find a county that will issue out-of-state permits.
That's probably the answer. However, when you run into a problem like yours, the best thing you can do is, before you go to that other option, is try and find that state organization. See if they have an organization that either has the funding or has a lawyer willing to volunteer their time to make that case And
Well, I have an attorney friend that's just chomping at the bit to do it. We just don't really know if it's worth the time or, I don't know.
Well, look, there's cases that I've done on behalf of Florida Carry or not on behalf of Florida Carry as a private counsel because it would be advantageous to Florida Carry. And so there's cases that I've done because I thought the issue was important, because I had the time, and hey, the state of Florida tells me I have to do so many pro bono hours a year. Not that I've ever even come close to doing the minimum. I've always gone well beyond that. But there's certain cases that are just so compelling and so interesting. It's tempting to not do them, and I do them and I love them, and we've had some good successes with them. There's other cases that I just can't take on because hey, I got a boss to answer to. I got a firm I work for. They're very generous with giving me leeway, and I have to treat that carefully and take the cases that I either think I can make great law on, make a name for the firm, or I got to be getting paid. It's got to be. If I ain't getting paid, I got to be doing something really important and really making a name for the firm, or an organization's got to be willing to put up the money for it.
Gotcha. Thanks.
Now, as far as the NRA/ILA, have you had any direct contact with them, and kind of what's your gut feeling on how they relate to, I say the little people, but the small organizations and the individual citizens, as it relates to our gun laws? I mean, are you seeing a pretty positive interaction? Do you feel like they're just blowing you off, or kind of appeasing you or humoring you for the moment, or do you think they're really behind these grassroots organizations?
Well, I have been an election volunteer coordinator, which is a program run by NRA/ILA to put a volunteer in every congressional district in the United States. I've been an election volunteer coordinator for the 4th Congressional District of Florida since 2002. In that role, my primary responsibility has been the people that get the magazine that say, yeah, I want to help. My number and name's on the front of it. They call me up and say, yeah, I want to help with this election, and I try and connect them with pro-gun candidates that the NRA is endorsing and make damn sure that candidate knows why they're getting these volunteers and where the support is coming from. Beyond that, the NRA/ILA I don't think has a lot of grassroots effect. Their primary grassroots efforts are getting those volunteers to help candidates and getting those networks of volunteers to then call that candidate and remind them how they got elected and where the people stand on an issue. That's what the ILA does great at. But I think the ILA is more of the top telling the soldiers the general telling the soldiers what to do, not necessarily listening a whole lot to what the soldiers are trying to tell the general is the concern where they live. And I think that's what differentiates groups like Florida Carry, Texas Carry, Mississippi Carry, Georgia Carry, Alabama Gun Rights, Bama Carry, Virginia Citizens Defense League, all these smaller state organizations. I think we're closer to our members. Our members tell us when they're having a problem. If I want help from the NRA's Civil Rights Defense Fund, it's put in an application, it's wait months till they have a meeting, and then they'll tell me whether or not they're going to help. We don't have that time most of the time. Most of the time, these people need help within a matter of days or weeks, not a matter of months. And so for those cases, it's groups like Florida Carry that are able to either help fund the case or help find funding for the case or find an attorney who's willing to volunteer their time to pursue the case and help this person that really needs the help.
Yeah, and it's not just on the litigation aspect, also in legislation. It really depends on what they see as the aspect and on what they see as their overall set of goals for the entire country, not just an individual state. So, yeah, there's a lot of things they'll do in an individual state, depending on what state you're in. In Florida, we've got it pretty good that we've developed a really good relationship with their Florida lobbyist, who has a lot of weight because, well, she's the former president of the NRA, and she's been doing this for over 30 years. She is the person responsible for Florida's concealed carry law, and in turn responsible for the concealed carry laws in most of the states in the country that have a concealed carry law. So if you're going to have a state organization that is going to work with NRA, you've got to have the right NRA personnel in place in your state. The ILA headquarters itself, they can sometimes be a bit leery of non-NRA affiliated state organizations. They think that their state organizations should be the ones doing everything, and look at us with a lot of suspicion, and sometimes, even in our case, will attempt to marginalize our message. So there's a little bit of dancing with the devil sometimes with NRA ILA.
But all that being said, being the size and at the national level like they are, they can do things that none of us individually can do, or even if we all work together, they have bigger numbers, so they do their job good when they're doing it.
Oh, absolutely. Look, Florida Carry has 12,000 members and supporters in the state of Florida. The NRA has 230,000 Florida members. That's a huge difference. They have millions. We have tens of thousands as far as dollars.
Remember, there are 1.2 million concealed carry holders in the state of Florida. Now, out of 1.2 million permits, we got 12,000 supporters of Florida Carry. We got 230,000 NRA people. So where the hell are the rest of them? And a lot of those are dual registrations. So where are the rest of them, and what do we do to get the rest of them involved?
That's a great point.
Untapped resource, right?
I
hope so.
There's a lot of numbers left over, that's for sure.
Sorry, I'm just looking through to see if I see any more questions here. So,
I've got
dead
one.
ear. Yeah, go ahead.
So the concept that you said something about that the NRA, when you're asking or answering the thing about the NRA, that they're not always being large, being at the national level, they're not going to see every situation unless it's brought up to them, and then even then they might not be able to act on every individual one. So my question is, and I like to be optimistic about stuff, do you think that the concept of the grassroots organizations like you guys at Florida Carry and the others, and then mixed with the concept of crowdsourcing, or the idea that those 14,000 members you've got, if they each threw $3 or $4 down for somebody, that's a pretty quick, $75,000 worth of legal defense. Do you think that if we encourage that, or if we were able to do that more often, in other words, bring adequate and hopefully overwhelming legal defense on basically the victim, the CCW holder who is involved in an LFI, do you think that we'd be able to turn the tables, or is it a tide that we'll just never be able to change? But I'm hoping that with the way the internet is going to bring individuals aware of these local things, if we're able to defend these gun things all the time with just overwhelming odds on our side, will they eventually just say it's not really worth going after these guys aggressively and go on to something else that they can go after easier, that's not going to fight back as much?
No, and I'll tell you why. What you suggest is necessary for us to defend lawful use of force cases, first of all. However, Zimmerman's a prime example, and there's been some other cases. We are our own worst enemies. Sean and I were talking about this a few weeks ago. I would be very careful before putting a concealed carry holder on a jury of a use of force case. I'd have to think long and hard about which if any concealed carry holders I'd want on that jury, because so many of us are so critical of any little mistake that a concealed carry holder makes when acting in self-defense. We have this idea of ourselves that we're perfect. We would never make the mistake that that person made. We would never make that error in judgment. And I think if you spend any time at all on any of the gun forums, you see this time and again, the criticisms that come out against whatever the use of force situation is. If there's anything in there, we will pick it apart to death about why didn't they do things differently.
Think about it this way. How many of you guys sitting on this chat have said, oh, well, I would never fire a warning shot. And if you fire a warning shot, that's a liability and that's a terrible thing to do, and your training should have told you never to do that. And if you fire a warning shot and somebody gets hurt, that's on you.
So,
however, I just laid out earlier a case where that was absolutely necessary because the person had no way to get the attention of the attackers other than scaring the bejesus out of him by firing a warning shot because he did not have a clear background to make any other type of shot.
So anyway, that's my first comment to this idea of overwhelming financial support to people who act in lawful use of force incidences. That's the first problem with that idea. The second problem with the idea of the overwhelming financial support is I'm not sure what the state of Florida's budget is. I know that the city of Jacksonville, where I live, has a budget larger than the 6 smallest state budgets in the country. So there are 6.
It just wouldn't be possible, in other words.
Yeah, there are 6 states with budgets smaller than this city, and this is a state of 20 million people. The state of Florida is about to pass the state of New York in terms of population. These state attorneys, they have an unlimited budget, and oh, by the way, if they have to spend several $1 million putting one murderer in jail, they just go back to the legislature next year and say, you know what, legislature, we had to spend this many millions of dollars putting this guy in jail because of those darn gun nuts and those and those scheming defense lawyers that ran us dry trying to put this one guy in jail.
So they actually use that as ammo against us politically.
Oh, absolutely they would. And at the end of the day, the only thing that's going to fundamentally change the way these cases are prosecuted, there was a provision in the Florida Stand Your Ground law when it was originally proposed. There was a provision that said if a state attorney brought charges against an individual who was found to be immune based on self-defense, that the state attorney was going to have to pay out of their budget for the defense cost of that individual. And, you know, of course, the sheriffs and the prosecuting attorneys had a cow. And they said, no, you can't do that. It's going to cost too much money. And so the state said, the legislature said, okay, we'll take that part out. And so they took that part out. Well, we see the result of that. The state attorneys have been left to do whatever the hell they want to do and not worry about what it's going to cost because it's not coming out of their pocket. Until it starts coming out of their pocket, you can forget any change happening in the only 2 ways the state attorney is going to change are the voters force them to by getting rid of the bad ones, or it starts hitting their bottom line to the point where they can't prosecute everything they want to prosecute, and the voters get tired of paying for them and vote them out of office. That's the only way we're going to change the way these prosecutors act towards self-defense cases. Look, the whole idea of the duty to retreat, it didn't come from legislate. Very few states legislate. I'm not aware. Actually, I take back. I don't know of a state where the legislature created a duty to retreat. Every case that I know of duty to retreat was a creation of the prosecutors conspiring with the judges. The prosecutors came up with the idea and convinced the judges to do it, or the judges came up with the idea and decided to do it on their own. And that's where this whole duty to retreat crap came from in the first place. It didn't come from legislatures. It didn't come from the people. It came from the prosecutors and the judges deciding that in the case of the judges, we're a more civilized society and people shouldn't take the law into their own hands. In the case of the prosecutors, we're the prosecutors. It's our job to punish people. The last thing we want is people running around protecting themselves because that takes away from our ability to do our job. And that's where the duty to retreat thing came from.
That's sort of like
Well,
legislation through prosecution.
And while we're on that kind of judge, whole court system thing, I mean, what do you, Ralph asked, what do you think of the direction of the Supreme Court lately? It's my understanding that we're really only holding there's only a one person swing vote right
Yeah,
now.
it's certainly not a majority. We have, a fairly good pro-gun bloc and a fairly bad anti-gun bloc, and we have Justice Kennedy acting as arbiter in the middle. And he's going to do what he thinks in his own mind is the way the country should go. And so there has to be a lot of care with what cases are brought to the Supreme Court right now. And even when Heller was brought up, there was a lot of fear that people didn't know which way Kennedy was going to come down on this whole idea of an individual right to bear arms. And there were a lot of organizations, including the NRA, that tried to kill that case. They really did not want to see somebody go to the Supreme Court, given their current makeup, and with this whole idea of an individual right to bear arms. Now, fortunately, Kennedy came down on our side and said, yes, obviously it's an individual right. But he's somebody who's really going to kind of go his own way, and you've really got to know what you're doing if you're going to bring a case to the Supreme Court right now.
Well, is it your, as part, and just specifically with you guys in FloridaCarry.org, is it part of your mission statement or part of your process to seek out pro-gun politicians and or judges?
Absolutely. We do not engage in partisan politics. I have some very good pro-gun Democrats. I have some very bad anti-gun Republicans. And we will oppose those anti-gun Republicans with everything we've got, and we will help those pro-gun Democrats with everything we've got.
All right, so let's see. Anybody else got anything? This has been flowing pretty well, but I'm running out of questions here, or at least what I can think of off the top of my head. I mean, when I end it, I'll probably be like, shit, I was going to ask him this and this.
Well, you got a lawyer here that's sitting here without his billing clock on, so get him in while you can.
We do appreciate it. In fact, a couple of guys in the chat have been saying they don't have questions, but they do want us to thank you for your time because it's excellent info. Hopefully we'll be able to do more of these in the future. These are awesome.
Yeah, I mean, whatever. Throw it out there. Throw it out there, whatever you got. No. All right, guys. Well, hell, I think that was...
scrolling through. Yeah, it's tough. They're having other conversations. I guess it's getting long in the tooth, I guess. I don't know. How long have we been going? It seems like we've only been talking for half an hour.
Yeah, we've been on right at an hour, a little over an hour, but it flowed so well. I mean, I think we were, I think it went by quick and stayed on topic for sure. It bounced around, but I think did a fantastic job at answering or fielding all the questions thrown at him.
Say the questions you think of, and we'll come back in a few weeks, and we'll do it again.
There you go. That's perfect. Before it becomes a train wreck.
There's quite often a lobby chat kind of after with kind of the public, so I'm not sure if that's going on or not tonight.
Yep, we'll definitely get somebody to get it going, and we'll post it there.
Eric, I don't know how tired you are, but if you're up for it.
I need about a 10 or 15 minute break, and I'll be back.
Cool deal. Well,
right,
man, I sure appreciate everybody tuning in and participating. I think this is definitely some good info we got across tonight. So before turns into a train wreck, this has been a great chat, so I'll end it here. And go check out gunchannels.com for the after chat. And everybody, check out floridacarry.org and do whatever you can to keep supporting these guys and their efforts to, protect and support our Second Amendment. So.
Well, we need volunteers with two things, time and money, and we can use both.
There you go. So, all right, guys. Well, hell, I appreciate it. Thanks for tuning in, and we'll see you next time.
Thank you.